Guys, there was a trial today, Kohberger
Mm-hmm.
trial. Some big news have come out of it. I watched it live. I know you guys were at work. Uh, basically, long story short, and we'll get into the hearing, and we're going to watch the hearing and kind of give our opinion on what's going on and what's being said in those moments as we go through it. But Kohberger loses. Two of the two things that he wanted. He wanted, well, one, the judge to reconsider the indictment and have it thrown out. The judge said no. And then the Kohberger team wanted to have an appeal go to the Supreme Court. And the judge said no as well. So all things that they were fighting for ended up getting denied, right? Now, what ended up being the biggest talk of discussion is the fact that even though that is the case, Kohberger's attorneys came out with reasons as to why they're not going to be able to present their case until summer of 2025. And the judge didn't set a trial date, but it appears that that's probably going to be the situation. It was sounded like two victories. And then even though it's not a loss, so to speak, for the prosecution, it is demoralizing. How do you guys feel that this trial is being pushed back a whole year? We'll start off with you, Jaime.
Dude, that's horrible for the families of the victims.
Yeah.
I'm sure they all wanna, even though they're gonna forget it, the situation. I'm sure they want some sort of closure, and for the trial to be held in 2025, if that,
Yeah.
it's just means they're gonna have to live through it a little bit longer, and then they're still gonna have to relive it when the trial starts.
Right. What about you, Big Blue? Were you at all surprised that the trial isn't going to happen on, in the summer of 2024?
I'm not surprised at all, because even like there's cases here that I've seen, the person got arrested 4 or 5 years ago and they barely do the trial now. They barely, I thought if it would be in the summer, that was a speedy trial. But what I saw on the videos today, I heard the defense's part, and I get a sense of why they're doing it, but it's like, okay, they're saying that they don't have enough time to review all the information because of how much the terabytes are and everything.
Mm-hmm.
They've had almost a year already, over a year, to be able to start reviewing most of it, of what they got. And then, the part where, you're the defense team and you say, well, I'm waiting for information to get sent to me. Oh, yeah, but then the police department told me they already sent it to me. I just had to find it, and all the stuff they sent me is like, okay, did you even go through it?
Right. You bring up a really good point there, Big Blue. They've had over a year with this case, and I understand that there are some things that they're saying that they haven't received, that they're still waiting on. I think that they were specific about a certain piece of footage that they're waiting on, pieces being put together, the audio being recombined or whatnot. And I understand that those things you need to have time to review those things and make sure you have everything. I'm a little bit surprised to a certain extent that they don't have everything. But you're what you're saying about it, a year, their complaint was that things weren't itemized. There wasn't an arrow pointing to where this evidence was and how they plan on presenting this evidence in court. The prosecution doesn't have to do that. They just have to give them the evidence. When the prosecution and law enforcement created this case against Kohberger, they didn't get this evidence itemized. They didn't get an arrow pointing, this direction or that direction. They had to gather all that information, put it together, and come up with a case. And they did so, from between November 13th, when the incident occurred, to December 30th, when he was arrested. That's just a little bit over a month. So, they got everything. I don't think that they deserve everything to be, given to them in the form in which it's going to be used against them. So I don't like that argument about it. What do you guys feel about that argument that the defense basically wants, everything as far as like how they plan on using this evidence against their client, things like that? We'll start off with you, Big Blue.
Sorry, my daughter was talking to me. Repeat the question. I'll answer it. But just
Yeah. So, man, I forgot what I was asking you. Dang it, Blue. Now, hold on. Let me think. Oh, yeah. So they've had a long time to come up with it. And, they didn't get those things itemized. Do you think that the defense should have a list of everything and how they plan on using it against their client? I think that there's secrecy aspect that needs to be, applied here for trial.
Yeah.
As far as how the game plan is, what are your thoughts?
Yeah, you're never gonna give the other team your playing cards. You're not gonna say, "Oh, I have a full house," and then they know what they need to get to beat you. But
Right.
they one thing that I do think is that as you listen in there, the excuses, they're saying, well, we need to talk to these witnesses, but they don't want to talk to us because of the publicity. Okay, you can subpoena them to court and have them talk to you. They can be subpoenaed in to give their
Right.
statements. I mean, that's an excuse to me. The other excuses, like, oh, the prosecution's already saying who their experts are. It's like, oh, well, we need to go through their notes so we can give to our expert notes and try to
Which
compare. Okay,
they haven't found experts, and we'll go through all that. You know what? Let's
yeah.
do that. Let's start this here. Let's listen to what they say and break down exactly what's going on during this court session. But before you do, Jaime, do you have any statements or anything you want to say before we start it? I know you're coughing, so you can say no.
I'm having like a cough attack. Now, what's it called? Yeah, I mean, when it comes down to the trial, the state is going to have the theory of what they think happened and the evidence, right?
Right.
And I mean, it's obviously it's up to the defense to like rebuttal that, make sure that that doesn't stick and make their client look like they are the ones that were there and committed the crime.
Right. Yeah.
And,
No, you're right.
and I think for them, for the witness thing, I mean, damn, it's been like you said, it's been more than a year.
Mm-hmm.
I think they should have already, questioned and spoke to some of them at least.
What it sounded like to me, and we'll go through it when we get there. It sounds like they're having problems getting anybody to come forward, especially when it came through, because they talked about two phases. They talk about, the innocence phase, which the male, I don't know what his name is, the male attorney, it didn't seem too optimistic that he's going to be found innocent during this trial. And you also have the sentencing phase, and they were talking about how they are having problems getting people to come and talk or on behalf of Kohberger, meaning like they're having a hard time finding anybody to say anything good about him, is what that means. And they want extra time to find somebody who's willing to come forward and say something good about the kid, the man. You know what I mean? And I think that that's something that they have a problem with. They also said that, they're having problems finding experts. Well, it's because, they're trying to find an expert that can align with their narrative. If they're having problems finding one, it's because their narrative is invalid.
Yeah, and the evidence is pretty solid.
Yep, 100%. So let's watch this.
We are addressing reconsideration of the order denying motion to dismiss the indictment. That order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case. I think that's all the preliminary. Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
Thank you, Your Honor. I'm going to, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process.
So the guy said right now, this isn't our attempt to delay anything. Yet once they get denied this, they want to talk about, pushing this trial further. And they're going to explain how this is a futile argument regardless, because they'll end up in square one. They're just trying to delay the inevitable, in my opinion. What do you guys think about this situation? Do you think it's a delay tactic?
Yeah, definitely, man. I mean, they're like you said before, it's kind of a little bit of their Hail Mary, just trying to just get some extra time to maybe find people or like witnesses that might be, talk at least good about their client.
Yeah.
So they can get someone like a character witness, pretty much.
Yeah. I mean, that's possible. What about you, Big Blue? What do you think?
I mean, I listened to what she mentioned, and the prosecution did agree on some parts, where this summer would have been too early for the case because they might need to review some of the information because they haven't got it all, or they got most of it, but it's a lot to go through. But they were pushing for March. Well, not pushing for March. They're pushing for this summer, but this, everybody knows that it might be too early for them. And
Right.
if they want a fair trial and they don't want to have to redo it twice, I think that's what they let's go ahead and go for next summer. But even at that, I mean, when you listen to his defense attorney, she's even skeptical of that time.
Yeah.
She's like, I'm already worried I'm not going to be ready by then. I'm like, okay, so you got another year and a half if it goes to next summer.
To be fair, right? In a single homicide situation, those court cases can take a while. In a double homicide situation, those take typically a little bit longer. So we should expect that a quadruple homicide probably would be, one of the more longer type of cases, to go with. And it's unfortunate. I thought that they were ready to go. They seemed confident that they were ready to go. Kohberger seemed he was confident at this arrest. He's made the statement allegedly that he was looking forward to being exonerated. Exonerated meaning found innocent, not beat something on a technicality. So it's kind of a weird strategy based on what he said and based on his intentions of, showing that he is innocent, because none of this argument shows that he's innocent. It's more of an
Yeah.
argument that, I want to get off on a technicality versus, there's a real killer out there. And
Yeah.
so,
I
that's
just-
kind of where.
it just varies on the case, you know what I mean? Like, I just saw a case that just we arrested the lady in August,
Uh-huh.
and I think she committed the crime June. They arrested her in August. They already sentenced her today. That's for just one person. She, and nobody's witnessed. I think it just the threats she was making. So they were convicted there in August, September. 6 months, 5 months. That's pretty quick.
Yeah. Well, I mean, it depends also like on the situation. If you have something that happens in the presence or view of an officer, that usually doesn't take very long. If you have something that happens, and there's surveillance cameras that are around, and that's pretty much the evidence that's used against you, that doesn't take very long. In this situation, in my opinion, the defense is trying to create more of an issue with evidence that there isn't, like, for instance, the IgG. And I'll go into why it's futile, just like this argument that they're making now. And once we get to that point, but it's all a delay. And I'm just kind of curious, what's the tactic there? Are they hoping that, maybe perhaps people will forget about this? Maybe perhaps during questioning, somebody might not remember something if they push it out far enough, or it might contradict what they said, because memory is a tricky thing. You know what I mean? So if they go to court 3-4 years after the fact, is somebody on the stand going to say something maybe they remember clearer later on, and it contradicts what they said that night? Whether it be, I heard another saying, right? Let's just say Dylan remembers, the killer say something else, and she says that in court, like, before that I heard this, or she doesn't remember a detail quite as she said it in her paperwork, and then you're looking at a situation where, like, oh, it's not the same, they're contradicting themselves, this, that, and a third, and try to get something going there. And I think that's why when they ask, or when they say that they're hoping to get Bryan Kohberger's alibi through cross examination, that might be it. Like, they're hoping to get somebody to say something that contradicts what they said, and if they hold it off long enough, they could exploit that. And or they're hoping somebody says something where, I'll give you guys an example, something happens between a certain time frame, and you're thinking that let's just say Blue's a witness, and he sees all these people driving by or whatever. And then Blue ends up testifying that he took a break between, or a 5-10 minute break. And then the guy says, oh, well, during that 5-10 minutes, that's when I went through there. Instead of saying, I passed by there during that time, he's saying that after the fact, knowing when Blue took his break. I hope that makes sense.
Yeah. It's like he wants the whole story so he can work around it and make excuses and kind of like alibis for each thing that they have, like each theory they have against him.
Yeah, exactly. And that's kind of where I'm at on this situation here. So continue. Let's continue this.
At every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Langston. Mr. Nye?
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out 2 factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today.
Did that make sense to you? Did you grasp what he just said there? And if so, where do you see the advantage there from the defense?
And besides the delay, that's it.
Yeah, that's it, right?
That's it.
Yeah.
That's it, man. And I think that's what they're trying to go for, just for the fact that they're trying to find out a little bit more so they can work around whatever theory they have against their client. That's all.
I agree. And this kind of reminds me of the IGG, and this is why. The reason why I think that the IGG argument is futile, it's redundant, that there's no point in it, is it's not being used against him. It wasn't used against him to get his warrants. So if you go look at the warrants for his cell phone pings, it doesn't say anywhere anything about the IGG. If you go look at the warrants for his GPS locations or the warrant for his DNA swab, none of those things say IGG. So the IGG was just like a tip. In fact, that's what they call it. And it's not being used against him. Now, if there is information or evidence that is collected that was collected illegally or wrong or whatever the case may be, what happens to that evidence is that evidence is not used against that person in court. Right? So it doesn't mean that the case is thrown out. It just means that that piece of evidence is no longer admissible in court. And that's when they have all these, hearings and stuff. And that's what they're trying to do with this IGG stuff. So in essence, what they're trying to do is take something that is not being used against him, something that is inadmissible in court, put it back in court. And the best thing that can happen with that is that piece of evidence can get back thrown out of court that was never being put or used in court. Because when it comes to the IGG and the fruit of the poisonous tree, is that poison part of the tree aspect starts at the point where something was done illegal or wrong. And when you look at the IGG, that occurs after the STR was created. The STR was created first. So if something happened with the IGG, everything after the IGG can be thrown out. Now, Bryan Kohberger wasn't linked to this case, confirmed linked through the IGG. It was through the STR profile, through his DNA swab, meaning that goes before the IGG. So fruit of the poisonous tree says if something was done wrong or illegal, it's from that point back. Any evidence or anything that was gathered from that point back. Well, that IGG point is back or further than the STR. So even if you get it put in, the most you can do is get it thrown out and you're back at square one. I hope I made that make sense.
Yeah. To me, it's just like a delay tactic. Let's jump through all these loops to give us more time to review the evidence because we're not ready. And the one of the main reasons why they were trying to shoot for summer is because like you'll hear in there about the schools and the type of traffic that is causing the havoc that is causing in town. So, but there's some good. The prosecution did bring up some good points in there. If you listen, there's some really good points about. They'll be here in a few minutes. You'll hear it.
Yeah. Well, let's get on to it.
We need to get to a trial in this case, and that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically stays this case. Hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay, as we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now,
so just to kind of summarize what he just meant by that, he said that if he allows this to go to the appellate court, that meaning the judge, and remember, this is just going to go all the way in circle back to square one, is that during the time that it's in the appellate court, there's nothing that can be done on the case. Nothing can be moved forward. You know, they're going to talk about change of venue or those type of things. Those things cannot be discussed or determined while this is an appellate court. So it's literally a stopping point until then. And if that would have happened, and it could have been a few months before that comes back, you're looking at probably 2026 as when this trial is going to begin. And you know, I wonder why somebody who's so innocent would be okay going to jail or staying held in jail for so many years. You know, that's just my opinion. But what do you guys think?
Yeah, no, definitely. Yeah, I mean, imagine it's already been a year and months from when it happened, and then to wait another 2 years if they want to appeal all this stuff. It's that's a long time. It's a long time, and I think the judge by denying those motions, I think is kind of putting his foot down, you know, letting them know that they want this to go forward as in a timely manner too. They don't want to rush it either, but in a timely manner where it's not as far as 2026.
Yeah. What do you think, Blue?
Yeah, I mean, I'm pretty sure that they're going to be nitpicking everything to get as much time as they can on the to review everything.
But do you think it's just solely to review?
I think it is. I think it's, you know, why not hire a couple more staff members, senior staff members from somewhere?
I mean, they did give her quite a bit of I think money and grants from the state. I think that this is going to cost the state of Idaho a huge amount of money. I mean, do you think that could be also a determining factor as to why she wants to prolong this? Is there a financial aspect to this on Ann Taylor's side, that if this continues to happen, you know, she's getting paid an hourly wage based on this case, you know, and she's talking about putting all her time and effort into this, and that she's continued to do that, and she wants to continue to do that. So it's not like she's just going to be sitting on her, you know, on her thumbs. She said she's going to continue to work throughout these years. So throughout that time, she's going to be getting an hourly wage. That is pretty high. You know, this is going to cost the state of Idaho and the taxpayers of Idaho a tremendous amount of money.
Well, I thought because she wasn't the signed attorney to him that
she is.
I know, but like that they only go by what the state pays, and state pays a minimum.
Nah, she asked for, I don't remember how much, and I think they gave her it to her. She's making it's quite a bit. But I mean, it takes a lot of time, effort. You know, she has to put all her other cases to the side. So it's literally the only case she's working on. So you pretty much, if that ends up being the case, like if I was a business owner, right? And, or like if I owned a restaurant and I had 30 tables, You know, if somebody wanted to rent out the entire, wanted the place for themselves, and they'd have to rent out the entire 30 tables. It's going to cost them more. You know what I mean? And
Yeah.
so,
But did you notice how they got one of the things they wanted was this type of, recording where the cameraman can't be zooming in and out on him to
I think that's BS, bro. And you know why? I'll
you
tell
can't
you
see
why.
his reactions and
No, I don't care about that. This is a public place. This is a public courtroom. You can record people or places out of the public eye. There's nothing illegal about that. And you can zoom in on whoever the hell you want as a right, just being a citizen of this country in a public place to do so. And they are literally taking the rights of the people away in this case. That should, for those that are, looking at this situation and are like pro-Constitution, which I am, innocent till proven guilty, things like that, that should upset you, knowing that they're violating your rights to, look at whatever you want in a public space.
yeah, and it is blurry regardless if you see it on this channel or if you see the actual one that's from the judge's Facebook. There's no zooming in on it. It's not even clear the clarity. You can't really see them.
Well, these cameras are the cameras that are used by the court.
Yeah, you can see everybody else's, but they're closer just because it's so far away. You can't even see, like, I can't even recognize his. I can recognize Bryan Kohberger, but the like his lawyers, I couldn't recognize her in the beginning. I was like, is that? And I thought he had changed at first when the other guy came and spoke for her. I was like, man, I never saw they changed the lawyer.
Nah, it's just somebody that helps. What do you think, Jaime?
Yeah, I don't see what the problem was with transmitting the court hearing,
Mhm.
like broadcasting it. I guess maybe because they want to protect his, the way he, like you said, like Blue said, the way he acts or lack thereof. But I mean, at that point, the trial should be the ones that be more important than just this hearing. At this hearing, you're not gonna get no reactions or nothing like that,
Right.
From the client, from Bryan Kohberger.
Well, even at the trial, I mean, isn't it the job of the jury not to follow the case online or throughout the media while they're as a juror? So they're not going to see the close-ups and the people talking about the lack of emotion or any of those things.
Yeah, but at the same time, like, let's just say he does come out not guilty. The fact that you have him on the TV throughout the whole trial, people already have the, they already judged him guilty.
Well, I mean,
and if he gets off by a not guilty verdict, that could jeopardize his safety, I guess you can say, because people get that bad, that bad juju from him from his character, just being the way he acts.
Right. No, and I understand that, but that's the double-edged sword that is the constitutional right of freedom of knowledge and public eye and public space.
Yeah, no, I totally get that.
It's a double-edged sword. And if you want to have the freedom to talk and the freedom to watch this on camera and have those freedoms to have an opinion, then you also have that understand that comes with other freedoms from other people who might oppose your opinion. And their freedom as well to express their opinions and thoughts. And, if you're a person, and I'm not saying that Bryan Kohberger is innocent, but if you're a person that's innocent going through some stuff, it's unfortunate, but there are reasons why you have a civil side to things. Like, for instance, in that movie, or not in the movie, in the docuseries on Netflix, American Nightmare, on a true story kidnapping. And, the police didn't believe them and all these other things. It came out that they were telling the truth, and they ended up being awarded, I think, $2 million. So, their actions have consequences and things like that. If Kohberger ends up coming out that he is innocent, that doesn't mean that he's going to be able to go and sue like Nancy Grace and all these other people, because, they're only reporting on the fact that he was arrested and charged with the situation. typically when that happens, more than likely the person did it. I mean, there's evidence to believe that the person did it. And like I used the word more than likely. Doesn't mean every time, right? And so they're reporting on those type of things. And, you know, it'd be different if he's acquitted and then they still continue to call him, you know, somebody that's taken the lives of innocent people. Does that make sense?
Yeah.
And I think it will happen more often in the whole case, because I think his channel is just to provide a glimpse into the courtroom. I don't think they want him to be used kind of like we're using it, but you know, somebody else already had it on their channel. So
yeah, I think also it's probably when they set it up, you can set up your live streams to go private as soon as they end. Why they did that, I don't know. I mean, it's a good question, but they did allow, I guess, the media to. Oh, you know what? It's probably to not give the appearance that they're monetized, you know, the trial, and that they're getting paid, and you know, getting viewers, and they're you know, those type of things. I think that might be the reson why.
Yeah, that's exactly why it is like that.
Yeah,
because there was no chat, nobody can donate. And I know I looked at that, I was like, oh, you can't even hit the like button on it, or the dislike button on it.
Yeah, so fortunately, Law and Crime recorded it, and we're able to watch it now. Let's go ahead, Blue.
I gotta head out, guys.
Oh yeah, Blue got called into work. So if you're nearby Rex Cabaret, number 7. Blue.
If you're at Rick's Cabaret, watch out for the stilettos. I don't want to bandage you up tonight, okay, guys? I'm really mad enough that I already worked the last 4 days, and the only reason I'm getting called in is because the HR department doesn't want to hire an X-ray tech overnight over there. So
don't hire me, man. I don't have any certifications or experience, but I'll go help them.
but I did stay at a holiday.
Yeah.
All right, Blue, you stay safe tonight, my man.
Yeah, take care, guys.
Take it easy. All right, let's continue this.
In full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We're talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Thank you, Mr. Nye. Mr. Watson? Reply.
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do.
This case will go on for 28 years. His lawyer said this case will go on for 28 years. What does that mean to you?
I don't know. For me, it means like they're gonna do whatever is possible, because like even like the prosecutor said, right, that they're waiting. They're also waiting for them to. The defense is waiting for the prosecution to give them evidence, right? But if they appeal, all that stuff's gonna end up stopping. They can't do anything with it. So not only is once it restarts, they're gonna start again getting that information to them, but it's gonna be way longer down the road.
Right.
And it's gonna take so long.
Right. Well, here's what I think it means. I think it means that they're gonna appeal and appeal and appeal.
Yeah.
And I think that means that they also think that they're probably gonna lose. I mean, if you're confident in your in your client, do you think it'd take 28 years to
Yeah.
figure out this case, or do you think
Can you-
that you're gonna have a resolution there in court?
Yeah, no, I mean, can you what do you think the victims' families are thinking when he said that, or how are they feeling when they hear him say that it's gonna take 28 years? That's exactly what they're thinking. It's like, oh, this guy's gonna appeal every motion. I'm just gonna put any motion in court, that way they can delay as much as they can. And that sucks for them, you know what I mean?
Right. No, it is. Right now, I can tell you exactly what they feel or say. I talked to Christy earlier. It's disappointing. They feel defeated. They had high expectations, and but it's part of the process, and something that when I've talked to her previously, I kind of not prepared her for, but I did say that, with cases like this, with how the defense is doing their stuff, with the motions that that they have, it sounds like they're trying to delay this as long as possible. And ended up being the situation. And I said, just be prepared. And, they thought that was the possibility as well, obviously. And, I feel bad, there needs to be resolution. And one thing that, I can say that has been a question mark, since this incident occurred, is the involvement of the university and the financial aspect of the University of Idaho and the impact that this case has had and the decisions that they've made for the betterment of the university over the court and the situation here. Like, for instance, making sure that the trial is going to happen in the summer instead of saying, all right, we can figure something out. If the prosecution says that there's a logistic problem in the town, then move the damn court. Change your venue. You can't have your cake and eat it too. You can't say, hey, I want it here, but under the perfect circumstances. I'm all for, everything going right and stuff like that, but I'm about truth and straightforward and straightforward. I think that that's bull crap, to want to wait until the summer.
Yeah. Yeah. I think that should have been one of the first things they should have noticed. If it's not going to work on the schedule with the school, then they should have just changed venues. Yeah.
Yeah. And all Ann Taylor has to do is bring up a situation and push it just a couple of weeks. And you have to wait an entire year because they don't want to do it during the fall or the spring.
Yep. Yep. And that's going to just prolong everything.
Yeah. Yeah. It's unfortunate, man.
Like even if they come to an agreement that they want to do it during the school year, they're going to somehow, some way, they're going to have to wait no matter what. Especially with all the traffic, media traffic and, people trying to get a glimpse and trying to get inside the court, stuff like that. It's gonna be pretty much a circus out there.
Yeah. Liz asked, where are they going to move it to? Japan? No, I'm not saying about move it somewhere where people don't know about the case. I'm talking about move it to a place where there isn't a college and a high school right around the corner of the courthouse, a place that because it's not a college town, they can facilitate more, hospitals, hotels and bedrooms for people that they're going to have to bring in, like the logistical things that they spoke about earlier, that is going to interfere with the high school, is going to interfere with the college and the universities. That those are the times when people, are in, people come and visit. They're the students of the university. So housing is an issue. So if you can't if you can't do this court or this trial in a timely manner, I would be upset if I was Bryan Kohberger and I said, hey, I'm ready to go to court and it's October and they're telling me I got to wait till June.
Yeah, no, the time slot's too small to be in that town. If you're expecting to do it when there's no school, because it's gonna, it's gonna be a problem because of the high school and the college, and they should have thought about that a long time ago and been to change the venue.
And I can probably, say that Ann Taylor has an appeal saying that, this court looked at the benefit of the city, the university, their financial aspect versus, the victims or the client's rights to have a fair trial, things like that. And it could cause some problems later. As if they said, hey, they only wanted to give us 6 weeks to do this, we expected 12, but because they're trying to fit it within a time frame, I can see there being some problems here, and I don't think that those problems are needed. I don't think that you need this case to be tried in front of judge in Latah County to get a conviction. I think that the evidence there is enough, and I think there's more than enough. In fact, we're going to hear a little brief bit about how much they have from Ann Taylor. Let's see. We have a super chat. Art Reese comes with $4.99. I think the delay tactic is to keep BK in a relatively nice jail and out of a not so nice state prison as long as possible. Yeah, that's probable. I mean, that's a good possibility. It is. I want to say thank you real quick to Afton Ford for hooking up a Drunk Turkey Show membership. Leticia Yetta saying, always a great night listening to y'all. Thank you so much. It's our 13-month year. Thank you.
Wow.
And Mountain Mama has been a member for 10 months. Congratulations. We appreciate you.
Thank you.
So yeah, let's continue this.
To actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong, and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
Okay. Excuse me. Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law, and I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So,
the judge is adding common sense to the defense's arguments. Like, we've already gone through this. We've gone through all the cases, all the laws, and just plain old common sense. Like, what does that say about the strength of the case of the defense?
I don't think it's bueno.
Neither do I, man. I mean, I think and I get it. Some people think that he's innocent or whatever, and you can have that opinion. Nobody faults anybody for having their own opinion.
Yeah.
But at a certain point, you kind of got to start reading between the lines, reading what's on the wall there. You have all this evidence against them, a lot more evidence than we even knew about. And there's nobody coming to speak up, for him. And outside of people that have already spoken to the media. Now, I knew that there was one guy that's come out on a couple of YouTube channels who knew Kohberger at a certain point in his life, back in high school or something, that he's defended him. I wonder if he's one of the persons that maybe could have been used as a possible, character witness for Kohberger. But because, like Ann Taylor says, they've been too far into the media that they can't, it wouldn't be probably in their benefit.
Yeah.
If you go out there and, look up some of these things and maybe look up some of the stuff that he may or may not have said. And I don't know if it would align with anything that would be, they could probably pick and choose some things and cherry pick what he says, put it in court, and it wouldn't look so good. You know what I mean?
Yeah. I think the judge right there went with the common sense statements like, dude, come on. Come on. We know what the state has. Come on. You're just bullshitting now. Come on.
Yeah, I agree, man. I agree 1,000%.
I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of you. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what this.
Do you think that this judge and this case is fazed by the attention of the nation, of the world? You know, I feel like there's a lot of stuff that they're doing that they probably wouldn't have done or even considered. You know, even that first, deal here about, the throwing it out for this reason. And, there are certain things that he has said, like the IGG, calling it a futile argument, and going through this, saying that it's common sense. Do you think that he's going through all these motions knowing that in most cases they're probably not going through these motions, but because of how much this case is looked at like under a microscope, that they feel like they have to go through everything?
Yeah, I mean, I think it's like a really high profile case, and I feel like there is that kind of pressure that they can't really overlook, even though, I mean, obviously I feel like he knows that it's kind of dumb for him to be asking these kind of motions, especially, knowing that like that he's seen and kind of has all these evidence against that client, against their client.
Do you think that these guys have defended somebody in the past for murder? I mean, I would assume so, right? Because they're able to.
I'm sure. Yeah, I'm sure they have.
Do you think that this argument has been brought up by these attorneys in other cases?
Definitely. It kind of, if they know about, I mean, if they feel like, even though they said that it's kind of rare, even just for the motion for the Supreme Court.
Right, but it hasn't. None of these attorneys have brought up this argument up until this point, because that's one of the arguments, is that this is an argument that nobody's talked about for the last few months.
Yeah, and I'm not really talking about that part, but I'm sure that in other cases they do want to put every single motion they can to delay, so they can get a little bit more time for themselves to look at the case in different aspects,
Right, pick apart something,
Yeah.
So what I'm saying is, or what I'm getting at is, the fact that they're arguing these specific points that have never been argued before. These are attorneys who have been in this state, who have probably represented, people that have been charged for murder, and they have never argued these points. Do you think that these points are coming from Kohberger directly?
No, I don't think so. I think that they're arguing that Supreme Court right now because they know that everybody's watching, and
that's a good point.
You know what I'm saying? That pressure is on the court for them they have to hear it out at least,
Yeah.
And I think that's why they're using it, so they can get the delay that they need.
Well, not so much the delay, but if you're wanting to get something pushed, if you have something like an agenda or a law or whatever you want pushed, and let's just say it's not happening, well, you bring it up in a high profile case and kind of, put the pressure on the court system to make, them look into that situation. And in this scenario, it's the IGG, because, the IGG has been used in like thousands of cases, to find and convict people, and never has the prosecution have to turn over the names of the people that were involved in the IGG, the innocent relatives, like what Kohberger and his defense team are asking for. You know, there is precedent against that. Like thousands of times, maybe not in Idaho on its own, which is why they have the argument. Outside of the state, there's precedent. So it's interesting. Let's just continue this.
Standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, I'm going to deny the permissive nature. Yes. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Knight said. So that's significantly more delay. So there's some other, actually, this is in a case law, Idaho versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
Do you want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Logston said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here. And frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential fulfillment. We are simply trying to fulfill our responsibilities under the law.
So he said, with facts like this, you think that means that they got some pretty strong evidence against them?
I think they do, and I think that they know they do. You know,
I do too, man.
yeah. I mean,
Like,
even from the beginning, I'm kind of figured, you know, the fact that they were so, you know, so confident about it, you know.
yeah.
So
Yeah,
I was like, oh, they must have some pretty good stuff. I mean, they have a lot of evidence that we don't know about. Obviously, they have a lot of stuff that we don't know about. And come to trial, we're gonna find those out, and it might turn a lot of people either from pro-burgers to non. You know.
Nah, I don't know, man. The one thing that I've noticed about human nature is the need to be right, and the need not to change your mind to fulfill the need to be right. You know what I'm saying? I've seen you know, some folks just, despite all the evidence, despite anything else, because their initial response and thought was, you know, one way, regardless if it's, you know, innocent or guilt or in anything in life.
Mm-hmm.
You know, it's seen under that veil, so to speak.
They'll die on that hill.
Yeah. Like the what is it, the saying, you know, to a hammer everything's a nail.
Mm-hmm.
It's kind of like that. And so you know, for me here, I'm very evidentiary, right? I like to look at evidence. What does that say? What does that point at? Right? Like, even when it comes to anything, like if like I talk about the Pittsburgh Steelers. I'm a huge Steelers fan. I have a Steelers channel, and in there I bring up points, right? Like, for instance, right now there's a quarterback battle that's going on. You know, there's been some statements made by the coach, by the franchise, by the receivers, and the running backs. So when I come up with my statements as far as what I think that the team is going to do, it's based on those statements and evidence that they've shown me that they're going to be moving in one direction or another. I do that in everything that I look at, very evidentiary. So in this case here, just looking at the evidence, it's pretty bad one way. Looking at Richard Allen's case, initially, I thought it was him alone, nobody else. You know, as more evidence comes out and more things come out, I'm open to the idea that there may have been somebody else involved. I still think he's involved based on the evidence that's there, but I do think that there's a possibility of something more. I don't get stuck on one thing. You know what I mean? And, you know, you can expect that out of this channel. We follow the evidence. If the evidence comes out and it shows, you know, that there's some question marks, then we're going to bring up those question marks and we're going to try to answer those question marks. Like, for instance, one of the biggest question marks was, why was there no DNA in the car? Well, come to find out that bleach dissipates after 24 hours or less. Come to find out that, you know, we speak with a forensic death investigator, somebody who has a master's degree in forensics, and they tell us that there's ways to clean blood up so that it doesn't show up, you know, later on. And knowing that he is a PhD student in criminology, probably has access or knowledge of how to do those things. And so once we get more information and we go and look at those type of things, that's when we can, you know, continue to make our mind up on a piece of evidence. A lot of people try to hold us down to us saying that if there's no DNA in the car, then he's innocent, which, one, wasn't what we said. Two, it was, you know, if there's no DNA in the car, that's going to be a big hurdle. That's going to be a big problem. You know, there was no DNA in the car. You know, we weren't going to just go all of a sudden say, hey, he's innocent no matter what other information that's out there, no matter what comes out, because this one thing, we're going to say that he's 100% innocent and needs to go free. Not necessarily. We're going to ask questions to try to explain why there was a disparity or, you know, something different than what was expected. And if it comes out when we find, you know, if I would have asked that death investigator, you know, that forensic death investigator, is it possible to clean this up? And they would have told me no, and that there's no way, and this, that, and a third. And then, you know, then I find out there's no way to, you know, if I were to have found out that bleach would have stayed on there for 3 months and you would have been able to have seen it, then yeah, you know, there'd be a lot more questions about why that DNA wasn't there. But you ask questions and you get answers and you found out, is it possible and why and how? And are the means there? Is this guy capable of cleaning this car without showing proof that he cleaned it? Does he have the training and knowledge in forensics to do so? Now, those are the questions that, go along with that problem. It's not just a one-word answer or one sentence solution. There's more to it. I hope that makes sense. So let's continue this.
Characterize it as the state is trying to kill someone. It's just simply appealing to raw emotion, and it has no place in this court. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, but she is waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize the defense has factors and considerations they want your honor to take into account, and certainly we want to afford them that opportunity. I will say, though, that, and we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as your honor knows, we have two universities, part of our community. And during the academic year, we have graduations. We have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, your honor. As I said, we filed this last month. At that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
Taylor?
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that. So that's just for the court's information. Your Honor, that in the...
So they're saying that no matter what, that they have to wait till 2025. That's when they feel that they can, have everything ready and be ready to go to trial. I think that's a little bit long. Like I said, even the judge is like, really, you want to push it out that far? I don't know, man. Like I said, it's a stall tactic. I said it from the beginning. I called almost all of this. I said that they're going to stall. I said they're going to stall from, the word go. They were going to waive the speedy trial. They did. And since then, every disposition stuff that they put out there was an attempt to stall, in my opinion. Now, there is some stuff that they say they haven't gotten. I think that the prosecution is working on getting it to them, which I do think is a little bit of a concern. I would have wanted this information, a lot of this information, way before now. And I do think that once they do get that information, they should be allotted X amount of time to review that information.
Mm-hmm.
But they're being vague on what the information is. And, you got to take it for what it is. It's coming from one side. So the description of what evidence that they may be waiting on may not be as important as they're alluding it to be. Does that make sense?
Yeah, not only that, but like you said, they're waiting for them to get the prosecution to give them stuff, right? And if they appeal to the Supreme Court, that's just going to halt everything. So it kind of like, so where we at now? You know what I mean?
Yeah.
Either you get it or you're gonna wait for it later on till later, and it's just gonna push back the date.
Yeah. Julia says, "What if a student is picked for jury?" In my opinion, that would be good. That'd be in his benefit. You're supposed to have, be tried amongst your peers. He's a student. A student would be a peer. What do you think?
A student? For what?
Yeah, it's like for grand jury or for jury. Let's just say once they do the jury and the University of Idaho student is selected for the jury.
Well, they can choose to stay, right? Like they can choose to be part of the jury, but they don't have to, right?
No, I mean, obviously, if you fight it enough, I don't think they'll make you stay. But I don't think so. I think that it is the decision between the prosecution and the defense who are
because they pick, right? Who stays?
Yeah, they would pick. Now, I would assume Ann Taylor would probably be against it.
Yeah, no, definitely. I don't think they would want a student to be there.
Right. I wouldn't think so either. But, by definition of the Constitution, you're to be judged by, 12 folks of your peers. A student would be a member of his peers, be about the right age, same, go to the same school, same age group. I would think that I don't see anything wrong with it. Let's go.
State scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial and the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order. And I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15-week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit.
Her saying that it's a 12 to 15 week trial. I mean, 12 to 15 weeks is what, 4 months?
Yeah.
So that's longer than what an average summer would be, or what students would be out of school.
Mm-hmm.
I think that this is an argument solely to change the venue.
Yeah.
The prosecution played their hand. They want to do it in the summer because they want to make sure that logistically it flies, right? There's not any issues. And Taylor knows that. It's like, all right, well, I'm going to make it more difficult for you to go into court outside of that time. That no matter what, it's going to be an inconvenience to the city, to the citizens, and to the University of Idaho.
Yeah. Yeah, and you can, obviously you're going to use the fact that, there was 4 victims of this. That's what makes the case and the trial a lot more, it's going to extend it because of so much evidence and stuff like that. So knowing that it's going to be 12, 15 weeks, they're going to have to change venues if they don't want to interrupt schools and stuff like that.
I agree. And, like I said, I think this is a tactic to get them to change the venue. It's a very good one. The judge had already, he's going to say that, hey, this sounds like a change of venue type of situation. And the prosecutor's like, no. We want it here. But I don't have a problem with it. The only thing is if they do a change of venue, I'm not sure, how that works. I'm not a lawyer, so I don't know how it works with the prosecutor. If it's a different prosecutor from the county in which he's being tried with or if Thompson is going to go to that other county and try him as the prosecutor, just, in somewhere else. I don't know how that goes. I'd be kind of interested in see how that works.
Yeah. I don't know if it will delay the trial or how long it will delay it if they do change venues,
And the other thing is too, if they're wanting to do this trial within 6 weeks, that tells me that they're going to try all of them at the same time. There is a tactic out there that they try them individually and he has to go to court 4 different times. That way, let's just say he comes up with this story or whatever the case may be in one court and he's, gets acquitted or a hung jury or whatever the case may be. The prosecution now knows how he's going to be, how he's going to attack the evidence. You know, they're going to know how he's going to attack the evidence, his alibi stuff, which they brought up, they're going to bring up his alibi. And, you know, let's just say he says, you know, the evidence, there's a gap, right? Let's just say there's a gap in the evidence, and he said, or in the time, and he says, no, I drove through there during that gap. Well, now that they know that during that time, they can go out there, you know, find cameras, do all these other things, and try to then come back at him the next time they go to trial saying, hey, this gap that you mentioned that you were supposed to be here, well, we went back, we got all this stuff, you're not there. So they may not be able to, let's just say you got acquitted on the first one, double jeopardy, won't be able to get, you know, try him for that first murder, then you can get him for the other three.
But wouldn't, if you try all of them at once and they find out not guilty, they can't can't charge them. Yeah, that's it, right? So it kind of, it has its pros and cons too, you know.
Yeah. But if they try him individually, then you're looking at like him being in court for over a year, probably.
Well, if they try them individually, it kind of makes me feel like, it will make me feel like the case, it wasn't as strong as I thought it is if they're trying them all at once. You know, you can
That's
tell
true.
that, you know what I mean?
Yeah, that's true. I think that if they try them all at once, that does show that they're very confident in their case. That does make sense. Good deal. Let's continue
about
this.
what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at two tracks of trial. We're looking at the innocence phase, where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence stage. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator, and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, this court knows everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have.
So she's basically saying that they have to get experts to, what it sounds like, or what she's making it sound like, is there's things that she's never seen before, or that haven't been used in court. And so they have to get their own experts to, do their test and things like that. And I think one of the things that she's going to bring up is the cast information and how that works. And the cast being the triangulation of his whereabouts. Now that is important to this case. Unlike the IGG, the cast information was used to get a warrant for Kohberger's arrest. And it was also used to get the DNA swab. So I have been worrisome of the triangulation evidence, because the warrant that they used to get that was his schooling and his specialized training and know-how on how to avoid or elude, a crime. And the fact that he drove a vehicle that matched the description of the vehicle that was being in the area. And the fact that, based on the warrant that they had for the towers They probably expanded that warrant. The one that we were aware of was the one where it was, for a 2-hour period after the murders and within a quarter-mile span. They probably expanded that for like a 10-mile radius and got Bryan Kohberger's phone disconnecting from the network at a certain time at 2:47 and then reconnecting at 4:48. So those are the reasons why they were able to get a warrant. And if they can go in there and somehow get that, those pings or whatever thrown out, that's going to be a huge blow to the prosecution. Now, I don't think that they are. I don't. The triangulation and CAS has been used countless of times. And at the end of the day, it's not really going to be what's used against him as far as court goes, because it was used to get the warrants. Once they got the warrants, one of the warrants that they went and got was for his GPS locations. That is way more accurate than any triangulation that's out there. So they have those locations. Those locations, those GPS spots are what's going to be used in court, and not the triangulation stuff. That has an accuracy issue, right? So in court, it's going to be the other stuff that's more secure. So the big concern is, if the CAS comes back that there's some issues with it and they can't use it, that's going to throw out a lot of information. Like I said, this one, this is the difference between the IGG and this stuff. This stuff was actually used against him, used to get warrants. As there's stuff there. If that gets thrown out, a lot can get thrown out. The IGG, it's bullcrap. There's nothing there. There's nothing after it. Go ahead.
And we talked about it a while back when we said that that's going to be a hurdle for the prosecution too, because the way they obtained that the warrant, right, was kind of iffy. Not that it was sketchy, but it was just like, I don't know if it was enough. We were talking about that too.
Yeah, I felt that it wasn't enough. I don't know. No, they didn't use the familial DNA. And what the familial DNA is, and I know a lot of people are getting confused, the familial with the IgG. Those are two separate things. Familial is where they took the trash out of his father's house and they matched his DNA as being the father of the suspect of the DNA that was left on the sheath. That happened after the fact too. So that's going to be the interesting one. But I think that, when you look at the history of CAST, you look at how it's been used in so many different courts and why they've had evidence to do so. I think it's there. It's a Hail Mary. But, that's one of the things that they're arguing really hard about. And I think that is probably their best argument that they have.
Yeah,
and I still think it's a long shot.
Yeah, because even if it gets thrown out, like they want it to get thrown out, do you think it will make the prosecution delay?
Run that by me again. What do you mean?
Like if they get that thrown out, like the cast and all that stuff, right? And the fact that maybe they didn't have enough to get those warrants, right? If they
everything's gone.
If they get that, obviously the prosecution's going to have to delay. That way they can get more evidence, right?
Yeah, the only thing I think what you can use against them if that gets thrown out is the familial DNA, right? There is nothing saying that you have to have a warrant or anything like that to go pull trash. Discarded trash can get pulled and can be tested. So that will probably still be able to be used. That'll link Bryan Kohberger, but you're not going to have the probable cause for the initial arrest. So that would have to be, the case would be thrown out. He'd have to get charged again without using those pings. Now, like I said, you can still utilize the familial DNA and then reintroduce the DNA that way, right? Because you have an avenue. Just because something was done wrong, or let's just say it was done wrong and they get it kicked out, doesn't mean that information can't be used against them. It just has to be found the right way and a different way. It can't be found the same way, right? So if they go to say, all right, we couldn't use the pings, but we went to his dad's house, we picked up trash that they discarded, we got a DNA hit, now we can get a warrant for his DNA and bring him in. Now he matches to the buccal swab. And what does he drive? Sure enough, it's a white Elantra. It matches what's on the camera, and you can kind of bring everything back into it except probably the locations. You won't be able to use that against them. And I think that's going to be a huge thing, because that's going to say that he had his phone off during the time of the murders. And that's a huge piece of evidence that his phone was off during a specific time. During that specific time, 4 murders were happening. And around that time, a vehicle matching his description, the description of his vehicles down to the missing front license plate, is seen in the area. Right after the murders is when the phone comes back on. So that would be a huge part of the evidence gone. But to be honest with you, it's like a wish and a prayer and hopeful wishing for that to happen. You know what I mean?
Yeah.
So, and there's a saying out here in Texas: you can wish in one hand and do something in another. We'll see which one gets filled up first. I'll leave it at that.
To go through. I know that the court has heard about 51 terabytes of information that we've received, and I want to tell you what that means. Miss Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that she was looking at Dropbox.com, and 51 terabytes of our discovery. To put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those, or 500 hours of high definition video. And we just have 1 of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets.
They have 1,300 filing cabinets of evidence against Bryan Kohberger. That's almost the amount of, no, it's not even close to the percentage that he was, 5 octillion percent the DNA that was on the sheath.
Yeah.
I mean, all right. I mean, somehow these 13 million document pages or this evidence that equates up to 13 million or 1,300 filing cabinets. Somehow there's an innocent story that equals all of that.
Right. She's saying that they don't have enough time to review all that. It's like, we'll get more staff because the prosecution apparently did it.
Yeah, exactly. They went through all of that and they were able to find the evidence to convict their guy, or not convict, I'm sorry, to charge their guy and arrest him.
And I'm sure not all of it is going to be evidence towards this case. I'm sure there's a lot of stuff that has nothing to do with it, but it's also in there. They have to review all that.
Right. Yeah, you're right. And, them reviewing all that and they have to have time. I get that, but they also have their client there. If their client can say, hey, I wasn't there, I was over here, then they don't have to go through 13 million or 500 hours of high HD definition, security footage. If he can say, no, you know what? I drove through Moscow, Idaho at 4:25. That's why I'm at 4:48 over there. That is 20 minutes after this person arrives. I wasn't even there. I was over here. They can go through all that tape, find that time frame, and say, hey, look, this is where he really was. But he's not telling them anything because, one, he knows, because he's a PhD criminology student. In criminology, I've taken a few criminology classes. They teach you case study and things like that. And one of the things they teach you is, if Kohberger tells them that he committed the crime or tells them details that makes them believe that he committed the crime, I'm not sure they can represent him anymore. And so he's not telling them anything that, would make them not be able to represent him.
Yeah. Yeah. He's staying hush hush about whatever he knows where he was at.
Right. And so now they got to go through everything too. It is what it is.
We have 51 terabytes, not just 1. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case.
So nobody wants to talk to them. They try to get to some witnesses. They don't want to talk to them. And the ones that they want to talk to may have talked to the media too much. I mean, I know that Enan Harsh was subpoenaed by the defense at one point, and he has been a guy that's talked to the media a lot. Do you think he's one of the guys that she's referring to?
Maybe. I mean, he also was promoting his YouTube channel, so I don't know.
But the thing is, too, he also said that he's seen a white Elantra out there. And you know what? Here's the other thing. While watching this, I felt that I think we're going to see evidence of not just Bryan Kohberger driving around that night, the night of the incident, but I think there's going to be footage of him there multiple times. Why else will there be so much evidence or such big files? It's probably, a lot of it is probably footage, right? Now, do you think that all of it is, based on what they said, it's 500 hours of HD, right? Of HD quality in 1 terabyte. And they have 51 of those. It was, they know that this incident occurred from the time that Bryan Kohberger left his apartment complex at 2:47 a.m. to the time that he returned at 5:36. So there's a 3-hour window there of maybe, let's just say, 100 cameras that they have. Well, that's 300 hours. There's still 200 hours to go. And that's just on 1 terabyte. So what that tells me is they probably have video evidence of him, not just on that night, but other nights and other days when he's probably stalking them to coincide and corroborate the evidence that they have with the phone pings. Because how else do you get so much evidence like that?
Yeah, man. I don't know.
That's what I'm thinking. I'm thinking they have him on camera stalking other nights.
Could be. It sure sounds like it, especially without us knowing the full extent of the evidence from what we got. I mean, we kind of, well, at least for me, points in his direction from what we have,
Yeah.
So I'm guessing obviously the prosecutors are going to feel like, not feel, but they know what evidence they have, what kind of video footage, pictures, all the data they have from his phone.
Yeah.
Yeah. I mean, they know they can, get a guilty verdict. That's why they're so confident. They want to push it. They don't want to push it as far as the defense wants to.
Yep. 100%. All right, let's continue this.
So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%. Well,
so there is 400 witnesses and they talked to less than 10%. So less than 40 people in the 13 months that they've had. They've talked to 40 people.
Even if they talk to every single witness, it doesn't mean they're all going to be brought up. Because they also have to give a list, right, or something like that of the witnesses they're going to bring up.
Yeah. And I mean, let's try to figure out who could be these 400 witnesses. Well, you're looking at whoever was at the parties that night, because they witnessed Ethan. They witnessed Xana. You have everybody at the corner club because they witnessed, Kaylee and Maddie there. You have everybody at the grub truck because they witnessed them there. You have everybody at the other party that that Ethan was at with his brother and his sister because they witnessed him out there that night. All right, and then you have those that they were brought up in the IGG. Those are considered witnesses as well. Then we know that the defense got some of those names. So does that equal up to around 400? I would assume so. And when you talk about the fraternity guys, a lot of those guys are in law and things like that, and are well familiar with law, and they don't want to talk to anybody. They don't want to talk to anybody about what they did. What's going on. They probably were doing some things that weren't legal, drinking, underage drinking, stuff like that. I don't think it's to the extent of committing a quadruple homicide. But there's that, and I mean, and I'm not saying that that's not a reason for them to talk or anything like that, but they probably don't know anything. They were probably just there that night, even if something may have occurred between Ethan and somebody else. Outside of that, they may not know a thing. So
Yeah.
what can they do to assist anybody? I mean, outside of, we saw Ethan, we saw Xana, they were at the party.
Mm-hmm. Yeah, that's what I'm saying. Like, even if they talk to all of them, they're not gonna get all those witnesses to come, because most of them are gonna they'll probably be present, but they're probably not gonna know much.
Right. Right.
If anything, maybe like 10 to 15 between both of them of witnesses. You'll probably, especially the ones that are actually like a lot more closer to the victims.
Yeah.
Those are going to be the ones, or the ones that were actually between, like you said, the bar, the truck, and then at the fight. Those are going to be mainly the ones that are going to be called
alleged fight. I don't even know if that's
alleged or the party. Let's see, right? Or the party.
Yeah. Because like I said, I don't know if that's true. And then, hey, if they try to somehow bring in the party that was at the house the night before, right? How many people were there? 150? Are they considering those guys witnesses as well?
I don't know. I wouldn't think so, because it was the night before, but I don't know. I guess they could also bring in like almost like character witnesses,
Well, yeah, they're going to try to do that, especially for the sentencing phase.
Yeah.
And say he's never done anything wrong, law-abiding citizen, blah blah blah. And I think they're having problems finding anybody that's willing to talk to them to give them that statement. That's outside of family,
including experts too. I feel like the experts, they're having a hard time with experts as well.
That I do as well. They're and it's weird because typically, the defense team, they buy their experts, and the experts that they buy will, articulate the evidence so that it matches their narrative. They'll kind of skew things or whatever and look at things kind of funny. And they can't even do that in this instance. As hard as they look to the side or squint, it's not looking good, I think. Let's continue.
Less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back.
So they want to go 3 generations back to talk about his life story. Now, I get that in the sentencing phase. Maybe. I don't understand what his grandpa or his great grandpa have to do, with his sentencing.
His secret brother, remember?
Oh, yeah, that's
I forgot about that, didn't you?
I forgot about the secret brother. To me, like, I get what they're saying. They got to go back. They got to do all this research. So that way, they can find somebody that can say something good about him. They have to go back 3 generations, for somebody to say, yeah, he's a good boy.
They're like 120 years old.
Right. Probably don't even know who Bryan Kohberger is.
On each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that.
Very old. I mean, the case happened just 13 months ago. How old are these documents that they're very old? You see, when it comes to those type of descriptions and things like that, it makes me question the validity of the things that she's saying and the possibility that the truth that she is speaking is highly exaggerated.
Right? Because even she's saying it's old, but in 2025, it's going to be older.
Right. I mean, it's just,
You know, they push it to 225, yeah, 2025.
right. No, I get it. And then, what they're saying is that the prosecution didn't hand them, their playbook. That's what they
Yeah.
want. They want their playbook. They want to know how they're going to use the evidence, what evidence out of all the evidence that they have that they're going to use against them. They don't have to tell them that. They have to supply them with the evidence that they're going to use against them, but they also have to give them other evidence that they're not using against them. And they don't have to say which part of the evidence that's going to be used against them or not. That's
No.
part of the, that's part of the court situation.
They want the
Right?
script. They want the
Yeah.
script. Yeah.
Yeah. They want the script.
And they want to re-edit.
Yeah. I think it was Mandy, one of our mods. She had put on Twitter, right? Because it was during Christmas, and she put on Twitter that she's going to go do Christmas shopping if anybody wants a cousin or an extra cousin or secret cousin or something like that. And I was like, I know a guy in Latah County that wishes he had different family members based on the DNA that caught him. So yeah. Well, let's continue this.
As well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us.
So right there, they have to find the experts, the right experts that are willing to work on the case with them. They haven't found these experts. Why?
Because these experts don't want to come on the stand and get broadsided by the prosecution.
That's true. I mean,
because obviously their expert is gonna have to, pretty much have his own, I guess, theory of why or why not the prosecutor's experts not right.
Yeah,
that's pretty much what it is.
Yeah, well, there's going to be an expert there to counteract whatever they say.
Yeah, exactly. So, like, if they can't find an expert or they haven't hired some, that means that they don't want to take that risk of going up there and getting a new one ripped.
Well, that, and I think that they can't find an expert because they know, or the last part, that are willing to work the case with us. They might be saying, hey, we want you to say this. And that guy's like, man, I can say that, but the prosecution is going to eat me alive. That's going to look bad for me in the future. Nobody's going to hire me in the future. Things like that. Again, this case is Hail Mary after Hail Mary after Hail Mary by the defense team. And I find it outrageous. I find it weird that some look at these Hail Marys as some sort of, vindication that he's innocent. I don't get it. I don't see it. I'm not seeing it.
I think them delaying is a victory for them.
Yeah. I don't know why. But yeah.
But I think that's what it is. I think that's from right now, that's all I see. That they consider a delay a victory.
Right. I mean, even like, and the thing is, I continually hear, we want justice, this, that, third. And I'm like, yeah, and I get it. And people are saying, he's innocent until proven guilty. And that's true. But what that means is that you can't, doesn't mean that you treat him as if he's innocent. There's evidence against him that created probable cause to put him in behind bars. And there's, there's a, what's the word I'm looking for? Like process that you have to go through. Right. And even if if he is innocent, and this is the process that he's going through, and there are a few people out there that have been charged with stuff and that have been found innocent. That was the process that they went through. But let's continue.
We do have several working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023.
All right, so let's break this down. They said that this discovery, the state probably shares the same issues. What has been the discovery issue that the state has been having problems gathering?
The IgG thing?
The IgG from the FBI, which isn't even going to be used against their client. So all of this goes back to the FBI not wanting to release the names of the people in the IgG, which aren't being used against him.
Yeah.
It's futile. It's pointless. There's another stall tactic. That's what I'm telling you guys. Stall tactic after stall tactic after stall tactic.
We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file, and there's tons of subfiles, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities, and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it, so you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up.
You know, the things that she's saying right there about photos, where and what, all that's on an evidence receipt. And so when pictures are taken and things like that and uploaded, all that is put on the evidence receipt. It's not going to be on the individual picture itself. It's probably going to be on the entire file of pictures. You know what I mean? And
yeah.
And she'll say it like the defense or the prosecution will say it's in there, and they'll point to a certain area and they have to go find it. They just don't want to do the work and look for it.
Yeah. No, I feel, well, I mean, not really sure how that works with the, the files and stuff like that, but I'm guessing it's like almost like a table of contents, right? It's like,
well,
like this picture is so and so, it's numbered and stuff like that, right?
Right, and it should be to a certain extent. I mean, you should be able to see who took the pictures, what day those pictures were taken. Like I said, those things are entered into evidence. It's typically with the evidence receipt. I never was a law enforcement in Idaho or any of those things, so I don't know how they work, but that information should be on the evidence receipt at the very least. I understand why they want it, and I think they should get it. They should get who took the pictures, when they took the pictures, and how they took the pictures. But the thing is, if they were given that information and they have to go through the documents to find it, then that's what they have to do. That's why they get paid so much money an hour. You know what I mean?
Yeah, it's especially if that's the only case she's working on right now.
Yeah, exactly.
There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons.
What are the things that they don't want them to have? The IgG stuff. So this kind of just boils back down to that. Just kind of want to point that out.
Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get
several days worth of video. So here's what I think that this is. This is probably like the Linda Lane footage, but maybe a different footage, right? And what they have there is probably the time that, based on what I'm understanding from what they said, is they have the times or the parts of the tape that matter on those situations. And let's just say that Bryan Kohberger, I think they accused him of going through there 12 different occasions. They might have the footage of, the 10th time and the 11th time, but not the days in between, not the information in between. So they want all of the footage throughout that entire time to see if anybody else was stalking the girls. You know what I'm saying? That's where they're going with this.
Yeah.
And that is critical for us to review and hear all of that. So that's an example, Your Honor. That is not us saying we just don't want to go to trial. We just want to drag our feet. That is us saying there are critical things that we don't have.
Now, they're saying they don't want to go to trial. They don't want to drag their feet. Yet they were filing a motion that would have put them back to square one, just kind of extending time, dragging their feet. Do you think that those two different things make sense? Can you say those two things, that you're willing to, expand the trial, delay it, not allow anything to go through because it's going to go into the power of the appeal court? So, change of venue, discovery, all of that other stuff is on pause. Mm-hmm. And best case scenario, they end up back to where they are.
Yeah. Are they debating themselves? Is it like an oxymoron?
It is. It doesn't make any sense. It don't make sense at all.
It's crazy, man. Crazy.
I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And
well, the cast information was in the probable cause affidavit. The cast information was used, according to the probable cause affidavit, in effects to get the search warrant for Bryan Kohberger. They utilized his cell phone data to find where he was at. Well, that data should be on that search warrant, because you kind of need that on a search warrant to get the search warrant. So I think it's there. They just got to go find it. And, she's going to make another statement where she doesn't know how law enforcement came on to Bryan Kohberger. I mean, I'm not an attorney and I don't know all the evidence, and I'm not a defense attorney, but I can explain how they found him to a T. So it's a little concerning. Maybe he doesn't have the best representation after all.
There are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then give them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received.
So she said that she has looked at every piece of discovery available. Then why the hell do they need to wait another year?
Why not? They already waited this long.
Right. She said, I've looked at everything. And she's saying that there's stuff that she doesn't have, but she's also going to say that the defense or the prosecution is going to say that, they pointed out some things and we haven't looked yet. So it might be there. Oh, I thought you looked at everything. She said she looked at everything. And later on, in just a few moments, she's going to say,
Liar.
she's going to say that, the defense is saying, or the prosecution is saying that this is where it's at and we haven't looked there. Oh, but you looked at everything. So why are you unsure where it's at? That was my pen, but it could have been a mic.
Discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue. I think the court's heard about this before. We've had bits and pieces of tips, and they've come in and we've reviewed them. But the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done. And
I agree with her on that one, at the 9,000 tips, that they should be able to have the allotted time to go through them. But, a whole year? I don't think so.
I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel, to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets. We constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as a court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance.
They're still in the circumstance that they need more information to complete Bryan Kohberger's alibi. Think about that for a second. They want more evidence that they have against him so that they can complete his alibi. If he is an innocent person, why do they need to fit his alibi to the evidence that they have? Why can't he just come out and say what his alibi is? Where exactly was he? Which direction did he travel after he turned off his phone? Because there would be evidence of that. If he said that he went to Coeur d'Alene after he left Pullman, Washington, and that he was driving up Coeur d'Alene and then went to another place and was driving around back way and came through Blaine, Idaho, and then traveled south on I-95, and that's when he decided to turn on his phone, that he never went through Moscow, Idaho. He went completely around it. Well, why not say that so they can go and look at the cameras that are going into Blaine, Idaho, or the cameras going into Coeur d'Alene and find his vehicle there? That would say, hey, it is impossible for Bryan Kohberger to be committing these murders and be driving around starting at 3:20, whatever it was when he started driving around. If he was in Coeur d'Alene at that time and not, past, then in Blaine, Idaho at 4:20 something or 4:30 something. So he could not have been the car passing by at 3:20, at 3:50, at 3:45. He could have been the car passing by at 4, because he was kind of close to that area, but it was impossible for him to be the other cars. And you know what? He would not be in jail. He would not be waiting another 2 years to go back to court. So just think about that for a second. He's unwilling to say that. I wonder why.
But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be, because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date. But I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those.
There it is. The prosecution has looked at places in the discovery that I may have missed, and I'll go look at those. So, basically what she's saying is, I'm not going to go look at the discovery so I can continue to stay that I haven't seen this evidence, so I can continue to make the argument that we didn't get it by using ignorance as an excuse to continue to fight this motion.
Damn. In the beginning of the case, a lot of people were praising her too.
Mm-hmm.
I don't know. I don't know what to say about that now.
Like I said, I mean, it's a tactic. If she went through the discovery and found all these things, then she can't argue that she doesn't have them. You get what I'm saying? You know what I mean? You know what I mean?
I know what you mean.
So she ain't going through it. That's why it's been 13 months and she hadn't seen Jack. And I don't mean decor. I'm talking about other things.
I was about to say that too.
You know, she hadn't seen anything and she hadn't seen anything. Why? Because she don't want to see it. Because if she does, then she can't argue certain things, right? Because if she finds it, right, and she found it, the prosecution will say, you see, it's in there. She just has to go look. All the other stuff that she wants, she can go and look and find it, right? Her saying, I can't find it, we didn't see it, blah, blah, blah. And they're hoping that the judge is going to order the prosecution to give them, you know, a hand-by-hand playbook of what the information is and the evidence that they plan on using and how they use it against their client. It is a tactic. And not one that's usually used by somebody that is innocent.
But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know.
All right, this is how the state decides on Bryan Kohberger. The New York Times figured it out, and they don't have all the evidence either. But they found out that the IGG came back on December 19th. The IGG, if you go and look at the FBI policy, cannot be utilized if there's a suspect or if there's any other normal ways of investigating a crime. All of those haven't been exhausted, right? It's meaning they have no other place to look. They don't know anybody. They don't know anyone. So what they did was they go and get, they get the DNA out the sheet. They send it out to Othram. Otham's trying to develop that IGG because Othram doesn't have to oblige by that FBI policy. Whereas that they have to wait till all law enforcement techniques have been exhausted. That's only an FBI policy. It's not federal law. It's not anything. So even if an FBI agent decided to do the IGG on their own without it, violating policy while they still had suspects, it doesn't eliminate that as evidence because it's not illegal. It's just against their work policy. Does that make sense? Like that's like saying that, you're going to get arrested because you violated a work policy because you were only supposed to have a lunch break and you took an hour and 15, and they're going to articulate that 15 minutes that you took extra was stealing money because they were paying you during that time. It's not how it works. So
it's like when they give you the free condiments at McDonald's and they're supposed to charge you, but they don't.
That's a good thing.
Yeah.
But that's how they decided on him. Once they got his name, it was December 19th. What happened December 16th? Oh, he got pulled over in Indiana twice by law enforcement on his way to Pennsylvania. Now, if you go look at the demeanor of those officers, they're hanging inside of the car. That is not how an officer approaches a quadruple homicide suspect, regardless of anything. Those officers, if they knew that this was the Elantra that the world was looking for in Moscow, Idaho, they know that, you have to assume as an officer that guy knows that or thinks that you're pulling him over to arrest him for that crime. And, somebody in that position can be unpredictable, right?
Yeah.
They can be desperate.
Yeah. I mean, if they knew, they would have considered him armed and dangerous, and they wouldn't be putting their arms on the window and just having a chat with them.
Right. Exactly. They wouldn't be doing that. That's not how you approach. That's an officer safety issue. And to be honest with you, if an internal affairs officer saw that conduct by that officer and he knew that was a quadruple homicide suspect, that officer would be under investigation for failure of police officer safety. And he could be fired for acting in that manner. So that they didn't know that, right? That was just by chance. I mean, the guy got pulled over how many times? He's just a bad driver, right? Maybe he's just a bad driver. He got pulled over in Moscow. He got pulled over in Indiana. He got pulled over, I don't know how many times. And if you go and you look at the probable cause affidavit, it states that they had to locate where Bryan Kohberger was by utilizing plate detectors or plate readers in Colorado on his way up on that trip. If they were onto him before December 19th and they were watching him, why would they have to utilize license plate readers after the fact to figure out where he was at? Because they didn't know where he was at. They didn't suspect him until the IGG came back. IGG came back December 19th. That's why all the warrants against Kohberger start after that. Phone pings to December 23rd. They go pick up the dad's DNA December 27th. They arrest him December 30th. So all those things happen after the 19th, and they happen fairly quickly. Once you get an idea of who your suspect is, and if that person truly, in fact, did commit the crime, and you start working things backwards, you're going to find evidence. Bryan Kohberger, if he committed this crime, he would have had to have left his house, sometime that morning and not return until after the crime was committed. Did he do so? Yes. If he committed this crime, he would have had to have driven a white launcher with a out front license plate. Did he do so? Yes. If he committed this crime, he would have had to have been in that area where this crime was committed. Does his phone put him there, or does his phone show that he was off grid, which is something that is a tactic typically used to elude the investigation of a murder? Yes. So, you start going down the boxes, boom, and you just start check marking all of them. Now, individually, one of those boxes doesn't mean that Bryan Kohberger, is guilty. But when you look at the totality of all the boxes and they all check off that it's him, you know what I'm saying?
No different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Okay, one more question. So sure. I understand this. I mean, I'm aware of amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
That's a tough question. If the state says you have everything, and I believe they can say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything.
I agree with her there. I don't disagree there that once they get the experts, information, they have to have time to go through it and check their T's and dot their I's. There's no argument there. That's his right. And, I don't think the prosecution is purposefully withholding evidence or information from the defense. Even the defense is stating that it's not them, that it's probably, just a situation of the process of gathering information from law enforcement and, from other places like the FBI who, when there's evidence that is not exculpatory, meaning that it doesn't point to somebody else other than Bryan Kohberger, and there's evidence that doesn't show anything. Like, for instance, if somebody were to have called and said, I think JLR Investigates is the real killer, and they use that as a tip, it's not going to go anywhere. There's nothing there. So they don't really have to disclose that aspect because there was nothing that was exculpatory about it. And especially if they were to investigate and they find out that that's just, somebody that hates on him. Right. And, they don't have that information wouldn't be sent to the defense. You know what I mean? So I think that like these 9,000 tips, there are probably a lot of that kind of stuff because they said that they got thousands upon thousands of tips. That last batch probably is that stuff there, and they got to go through all that. And I don't know, man. They've had a long time already. It just kind of does seem like they're sitting on their hands.
Sure seems like
There's
it.
just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase.
See, they are having a hard time having people talk to them both for the innocent phase and the mitigation phase, should we get there. Meaning they're having a hard time finding anybody that's willing to talk for them. The mitigation phase is the character witness phase. That's the people that go ahead.
It seems like they're blaming the media for it, right?
Kind of, sort of. I think that they are. They're saying that because of the media, people think that he's guilty and nobody wants to help them. Yeah. Nobody wants to be, go up there and say that they were friends with a person that's been accused of committing this crime. And if he ends up being, found guilty, which that's the part where they would be used in mitigation, is if he's guilty. They don't need them in mitigation if he's not guilty, right?
Yeah.
So
but they can also get the witnesses and get it back, get backlash for it too.
Yeah.
And that's why a lot of people aren't willing to go out there too.
Right. So the part that they're asking people to come forward on are like saying, hey, if Bryan Kohberger gets found guilty of killing 4 innocent people, we want you to come up on stage in front of the entire world, or on the stand in front of the entire world, and tell us why he's a good person and his life should not be taken. Like, I don't know how many people are going to be willing to do that, especially if you didn't really have a lot of positive interactions. If he had some positive interactions with some people,
a little bit of stories,
best friends. Yeah, I'm pretty sure some people would come forward and say, hey, I knew Bryan. He wasn't this kind of person. He didn't commit this crime. He was a law-abiding citizen. He was a good kid.
Mm-hmm.
Like, nobody's willing to come out and say that. I mean, read the writing on the wall.
If we ever get there, I have significant concerns. We're working on it. If you could say everything's going to go according to plan, I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you, and the records you need will be given to you when you ask, and the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March.
The witnesses not slam the door in your face. I mean, I think they're going to get more of that, to be honest with you. I don't think that's going to change. And again,
of 2025.
This is through the mitigation part. So these are the people that Bryan Kohberger probably has told his lawyers, because they probably asked him, like, can you give us a list of people that would talk good about you? Because we need that. And they slammed the door in her face. He don't have anybody on his side, y'all. And from what I've heard, I think that extends to the family too. His family.
And that's me saying I'm going to spend every possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you that.
She's thinking 2026.
Man, we're going to get GTA 6 before we get this trial going.
We're going to have a PlayStation 7 before this trial starts going, man. That's what it seems like. This thing's taking forever. And, here's the thing. If they have that much evidence against Kohberger, and his attorneys are already talking about going to battle for the next 28 years, meaning that they're already prepared for a conviction and that they're going to have to appeal. Why not extend the length or delay? Because at the end of the day, it's not going to affect him in a negative manner. Now, if he was innocent, you're taking his freedom away. If you go to court and you can prove that he's innocent, and all this time that he would have been waiting for trial, he would be a free man, and he'd probably be arguing for that to happen. But the fact that he's not, and he's willing to stay in jail for an extra year on top of what he's stayed in jail already, kind of tells you that that's probably the best case scenario for him. And I don't know. I mean, like I said, read the writing on the wall.
This is priority for everybody, and I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back. We can only predict the future so much, and I have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays in with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, most of all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year.
I just want to bring up what Corey said because our media has already found him guilty and people bought it. And I think that they're referring to why people don't want to talk to Ann Taylor and stuff like that. And yes, that's, that could be true. I think that the probable cause affidavit and the information that's out there, I find it hard that most people don't buy it, but it is what it is. But these are people, again, who are supposed to have known Kohberger the best. These are people in mitigation that are going to fight for his life. If he's found guilty, the closest people, your ride or dies, your that down person. I don't know how, those slang words than me, more than me.
The homies,
the BFF,
the confidant,
the sisters.
All right, that's a little bit too long.
That's a little too long. Yeah. But, at the end of the day, and what I mean by this is I'm talking about his family members. They aren't going to come out and speak on his behalf. Maybe not both of them. I don't know. And, like I said, no one wants to talk on his behalf. No one wants to say he's a good guy. And he hasn't been found guilty yet. This is after the fact, right? This is if he's found guilty. But nobody yet at this point. Just glad to be here for this long. Thank you. Yeah, we're about probably about another 15 minutes before we're out.
For the reasons
thanks
that
for everybody
I've
hanging
described
out.
to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them. And there won't be undue interruptions in the community that can cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And, I don't think that's going to change anything, Judge. When this case has national, if not international attention. This spring, I was at an association.
See, I don't think he understands what the judge was trying to say there as far as the change of venue. He was talking about the logistics of it. You're saying that, the spring or the summer is the best time because of the school and the high school and this. And he's like, well, it looks like we might be going into a change of venue type of situation. I think they should. They should already do it that way. That's already out. It's gone. Move forward. Go on with the next thing because, there's already some problems there. Let's get this done as fast as can. You don't want to have that situation hold us on to 2026. Thank you, Gail, for your $5 super chat. We appreciate that. Thank you so much. And you had a $5 super chat earlier. Appreciate you so much for your donations and your support. Thank you all for those that donate and support. We couldn't do this without you guys.
Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have friends in this community who have traveled to Mexico, and they say, people who are from Moscow, and immediately they want to talk about this case. It's not Moscow. It's not Latah County. It's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first. And not just rely on, there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court clerk down there, and they happened to mention co-rotation. Said, what are you talking about? So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging. But I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Latah County.
Yeah. Thank you, Mr. Thompson. So you're saying, looking at this realistically and the amount of information, evidence, non-evidence, that you might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty. And that's painful. It's an everyday reminder. And they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal. It doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah. I want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe in March 2025. Which Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. There's going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we only have to do it one time because we don't want to do this twice. We don't want to do this 3 times because no matter what happens, okay, if he's convicted, it's going to be appeal, and that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life is hanging over your head. So, sorry. We'll see. All right, so I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing.
Well, and that's basically it. And it sounds like he's going to, what do you call it? Probably put the trial at 2025.
Yeah,
I don't think there's anything that they can do about that. It just sucks, man. You know?
Yeah.
I feel bad for the victims' families.
Yeah, no, definitely.
This is the last thing that we're going to look at. This was an interview that was on ABC of the Goncalves family, and there's some new information that they spoke about. I wanted you guys to hear.
Kaylee's room that was full and appeared untouched.
We opened it. It was a little squeezy applesauce thing like you would give to like a toddler.
Yeah.
It did not appear to have been gone through.
Police saying they had gathered more than 100 pieces of.
I'm going to rewind that a little bit real quick. And I'm going to turn it down. It's like piercing my ears.
On a full digital copy of Kaylee's phone from authorities.
These are the last moments of your child's life, and you're sitting here fighting with somebody who just doesn't care.
They were able to collect some of Kaylee's belongings from the university over the summer, which raised concerns for them about how well possible evidence was processed, including a trash can from Kaylee's room that was full and appeared untouched.
We opened it. It was a little squeezy applesauce thing like you would give to like a toddler.
Yeah.
It did not appear to have been gone through.
Police saying they had gathered more than 100 pieces of physical evidence from the scene, along with some 4,000 photos and 3D scans of the residence. Still, frustration mounting for the family over what they consider a lack of communication and a rush to tear down the home on King Road. Christy describes for the first time how Kaylee was found.
It's my understanding Kaylee was kind of sitting up and had fought.
Yeah. And the way that room's put together, if you come through that door, you can't get out of that room.
Completely, totally trapped.
Yeah. You're in the bed.
Tiny room. The bed was the entire room. You could barely open up the door without swiping the foot of the bed. And it was wall. You know, the headboard was up against the wall. The side where Kaylee was on was up against the wall. And if you can imagine Kaylee in an upright sort of position, up in the corner, slumped. I mean, she was trapped.
The home on King Road was torn down in the pre-dawn hours of December 28th.
So there it is. Apparently she was in the corners, set up, slumped over, trapped. Yeah, they said that she fought. You know, she may have fought, but, you know, probably being woken up after a night of drinking, you know, surprised. It's the middle of the night. It's dark. Guy dressed in black with a 7-inch blade in his hand. You know, you can fight, but I mean, you know, like we said, there's audio from 50 feet away that pick up a dog barking, a thud, whimpering, doesn't pick up screaming or fighting. So it's unimaginable to think of how she got into that position.
Yeah. I mean, obviously, there had to be a lot more noise than they're saying, you know.
Well, you would think so.
Even just for the assailant.
I mean, you would think so, you know, but if the audio don't show it or don't display it, it just makes it weird. You know, you almost ask yourself, was she staged that way? You know what I mean?
Yeah, definitely.
Because, you know, if he attacks her and attacks, you know, both of them, one of, you know, Maddie's probably asleep. She's probably the first one. And she's, you know, Kaylee probably does awaken to that. And I'm not sure how much longer after she woke up that she was struck for the first time. Right. And, you know, depending on where she was struck is going to impact her ability to fight. Now, we don't hear any screams or anything like that, so I would assume that either she was in, so much fright that she didn't yell, or she was struck in an area where she wouldn't be able to yell. And if that be the case, her getting in the corner like that, I just kind of wonder if it was staged.
I don't know.
You know what I mean?
Sad situation.
It is 100%. And somebody brings up a great question, comment, says Xana and Ethan didn't hear anything either. I mean, we don't know that for a fact, but they didn't scream or anything like that either. They were the ones closest towards, the camera. I do think that maybe perhaps Xana heard something, walked up to the stairway there, maybe heard something else and said, I think someone's here. Based on what they were hearing upstairs, turns around to go tell her boyfriend Ethan. At that point, Kohberger comes down the stairs, comes up behind her, and as she enters the bedroom, he surprised her from behind. That's why he's able to get into the room with it, because apparently it was able to lock. Gets into the room, gets her by surprise. Ethan's still asleep. He might wake up in that moment, but he's looking up at a guy that's about 6'1", 230 pounds, with a 7-inch blade in his hand, and that has position over him. You can be the strongest, biggest guy in the world, but in that position, it's you don't have much of a position. You know what I mean?
Yeah. No, yeah.
Sad stuff, man. Sad case. It's unfortunate information that we're hearing that this case is going to be moved probably to 2025. We're going to continue to cover this and continue to cover everything that comes out up to the minute, up to the date. So make sure you like and subscribe, ring that notification bell. Jaime, do you have any final words for everybody before we let them all go?
I just want to say thanks to everyone that's here. I know it was a long one, so thanks for sticking it out with us. It was fun, but I got 6% on my computer, so I'll see y'all later.
You know it, man. This calling it off at the perfect time. That being said, we'll be back probably this weekend doing our members live. I'll keep you guys posted. Keep an eye in the community post so that way you're aware.